We can start this thing. Whoever else comes, they come. So data privacy is a really cool changing landscape, and they had some time for me to talk, so I figured I would. I mostly am going to cover Gdpr, which is the European stuff, Cpra or Ccpa, which is the California stuff, and overall data privacy practices, but I mean, there's a lot more to it. I'll try to extrapolate where I can. I am, of course, Bunny Smith. I am Consul's department head, but also in addition to that, I am the Global Cybersecurity Counsel for Yahoo. So I actually do not represent Yahoo in my statements. I am in no way speaking on their behalf. Neither am I speaking for MAGFest, which leads me to, I am a lawyer. I am not your lawyer. So any questions you want to ask, I can answer on various generalized topics, but I'm unable to answer things that are very specific to you because I am not giving legal advice of any kind. So we're going to cover, what does data privacy mean? What kind of data do companies collect so that you know who's collecting what on you? How, if you're running a small business or something, hey, I'm not a marketing company, why do I care? Well, I'll tell you why. What are the latest rules changes and how you're going to follow them? So, as I was saying previously, I am a lawyer. I am not your lawyer. So this is not legal advice. This is not advice representing Yahoo's or MAGFest's viewpoints. Nothing I'm saying is creating an attorney-client relationship. So please don't ask very personal questions that need legal advice. You can ask generalized ones. And apparently I'm already being cautioned to speak into the microphone. If you absolutely need legal help, I'm more than happy to point you in the direction of how to find an attorney, but that's about the extent of that. So, what does data privacy actually mean? When we're talking about data privacy, or when I'm going to talk about it today, it's about the process of protecting personally identifiable information. That personally identifiable information, it's real easy to think about your address, your name, your email, your phone number, social security number, that kind of a thing. Those are easy. There's also biometrics. You may think of maybe your thumbprint, but also when you scan your face into your phone, or when you scan your irises into Clear or some of the government websites, those are also counted as personally identifiable information, PII. Some of the safety measures that actually keep those in place that we have decided as a society we want to implement include firewalls, encryption, also training employees. That's considered a safety measure. When you get those stupid, boring trainings at work that are just like, hey, don't write your password on a Post-it note, that's considered a safety measure that we're taking, because there's actually a lot of people that don't necessarily follow all of those measures. In addition, hashing and obscuring things. So for instance, if you've ever had to put your phone number or your password into a website and you saw little black dots or stars, that's also seen as a security measure. That's not just on the front half. You'll actually see that if you go into the backside as well to say, hey, this is obscured from view. And the reason that this happens is because if there's a data leak, you don't want plain text viewed by people who are going to have malicious intent. So companies are, in fact, doing their best to protect you on many different fronts. They don't always get it right, but the next time you build a better mousetrap, there's always a better hacker to get around it, unfortunately. So what kind of information are these companies collecting? What kind of data do they collect and from where? One of the biggest ones is Facebook and Twitter scraping. I have really unfortunate news to those of you who locked down your Facebook. It ain't enough. One of the things you may not think about with Facebook is if you've ever visited a news article, say Time Magazine, New York Post, whatever, and you see one of those little buttons that's got the Twitter symbol or the Meta symbol on it, those actually are taking your data. They're saying this person with a Facebook profile has visited our website, and they're selling that information right back to Facebook. So when you decide, hey, I'm going to share this on Facebook, or I'm going to visit this from somebody else's shared post, that's creating identifiable information from you that is getting sold. In addition, Google scraping. As we all know, Google has all of our information from search history to what's in your email to they could probably identify your blood type at this point, honestly. So they are able to aggregate a lot of these pieces of information and create detailed profiles on you, which is unfortunate, but you as a consumer being better armed and better prepared and knowing that people are taking this data are able to better mitigate some of these strategies. If you're a small business owner, you can actually tap into these collections of data and say, hey, I want to target certain subjects or people. And that's how people are buying your data on the back end. That's why you are, in fact, not the consumer of Facebook and not the consumer of Google. You are the product. Finally, clear pixels and web beacons. There is no way to get around this one. What these are is a single pixel that is absolutely transparent, that is placed on a web page, and its only function is to track how long you spend on a web page, where your mouse goes, what your ISP is, all of this. The good news is, if you're from California, you have an out. You have the ability to contact these people. I'll get into that more later. But if you're from anywhere else, all you can do is request a copy of your information. That's coming along and will get improved in 2022, but we're not there yet. As of right now, you can't see those pixels. There is no way to track it outside of going into what the actual code of the page is, and they're going to be sending information back. Locally, how do people collect your information? If anybody has ever signed up for a birthday thing in your local restaurant and saying, hey, I want a coupon for my birthday. They're tracking your information there, how many times you come in, what you spend, what you order. Also, additionally, shopping or spending trends. If anybody has ever downloaded the Target app on their phone, Target actually has Wi-Fi all through in their stores. So if you have the Target app on your phone, even if you have not enabled Wi-Fi or Bluetooth, it is tracking you through the store. It is letting Target know what aisles you're in for how long and where you stop. So they can actually track you all the way through, and that's something that's useful to them as a business. So knowing how these systems track you and track your data is really important, because then you're going to have a clearer idea of what's being sold or bought with regards to you. So you look at all this and you go, I'm not a marketing company. I don't care. Like, well, why am I concerned about all of these different strictures? Well, the average Joe needs to know how to protect themselves against all of this, and needs to know what the strategies are that businesses are using when it comes to buying, collecting, and selling data. So if you are better armed, you can better prepare yourself and how you are presenting to other people so that you can have a data cache that is your own, so you can protect yourself better. We live in an interconnected world. This means that when somebody says, oh yes, this other government is buying US data, that means that if you travel to that other place or you buy products from that other place, your data is going to be collected and connected to that. So that's definitely something that you want to keep track of. I know, I'm turning you all paranoid right now. I promise there's payoff. The things that we're trying to, make sure that everybody keeps an eye on is transparency, consent, and choice. These are the three tenets that guide our federal rules, in addition to Gdpr, the EU law, Cpra, and other international privacy regulations, with a few exceptions. But it's the point of transparency, knowing how and who is using your data, consent, allowing or disallowing those companies to use your data, and choice, feeling free to select how a company is allowed to retain or destroy the data they have on you. I'm going to sort of buzz through questions so that we can do things at the end or what have you, unless anybody's got something burning. Good. All right, federal rules. What exists to protect your data in this country? First off is CAN spam. This is great. It controls the assault of non-solicited pornography and marketing act. This is essentially why you have all those unsubscribe links at the bottom of emails. It also states that, hey, if you actually unsubscribe from somewhere and they keep sending you emails, you can actually launch a lawsuit against them. HIPAA, and please note, HIPAA has two A's, not two P's. HIPPA is just a hippo that you've misspelled. HIPAA, HIPAA, is the Health Insurance Portability and Accountability Act. This primarily pertains to doctors and healthcare service providers. A good example of this that people aren't thinking about is COVID tests. If you get a rapid COVID test that is not from a pharmacy like CVS or Walgreens, you better be looking at that fine print and seeing how they're going to use your data. I actually walked out of a place because they said that my COVID results and all of my biometric data were going to be sold to a medical marketing company if I decided to take a test there, and I peaced out. So please, I know it's boring, but take a look at those things and make sure that if you're going to get rapid COVID tests, any kind of rapid testing from STD centers or what have you, anything that shares personal health data, that they have the right protections, or otherwise, don't do it. It's not worth it. Ccpa, this is for anybody that has children or is associated with children. It's the Children Online's Privacy Protection Act. The most visible implementation of this recently has been the complaints against TikTok, that TikTok was actually being marketed to kids under 13 and they were doing the dances and what have you. And as it turns out, yeah, you can't do that without a lot more protection because, I mean, ostensibly what they found out is there were people who wanted to do ill to children who were subscribing to these videos and trying to track people down. So that's why we have Ccpa in place to protect kids. And finally, Ccpa, Telephone Consumer Protection Act. This regulates the use of telephone systems. So, for instance, all those SMS messages that you get that have unsubscribe, stop, help links, that's because of Ccpa. Recently, there was a case that was in Florida and Indiana that had to do with the movie Checkers, or sorry, not movie, the restaurant Checkers. I believe there was another one that was done by Red Robin, and those were, hey, let's text you as part of our, marketing club, and we'll give you, however many dollars off of a chicken sandwich. And even after somebody pressed stop, they kept receiving the SMS messages. I believe they ended up having to settle for $2 million this time and $20 million the time before. So, keep an eye on that. You have rights under these federal laws, and you absolutely should be able to enforce them. So this is why I'm going to do a plug for somebody who isn't me. There's a TikTok star called The Lawyer Angela. She's fantastic. She actually talks about different class action suits that are going on that you can apply to very easily. It's a really good way to monitor your data, as well as monitoring, what kind of ills are out there. For instance, she was really big on the sunscreen one from Neutrogena because all of the SPF numbers on Neutrogena were wrong. So, you do think you're using 50, you're not. So the Lawyer Angela is her name on TikTok. But outside of that, these laws are here so that you can have protections, and more are coming down the pike. So as much as I've made you guys paranoid, I want you to know that there are protections in place, and the stuff that's coming up from places like California and Europe are more stringent. So there are more protections coming, and it is getting better in the industry. So GDPR, this is the General Data Protection Regulation. It officially came into being in May of 2018. There was a 2-year grace period before that for businesses to come up to play, but there where you could still actually do prosecution. So a couple of companies got stuck in this, one of which was Ford, who decided, yeah, we're going to email you to let you know that we're going to stop emailing you. Yeah, you can't do that. So if they've said no, you can't email them anymore. That's not how that works. So they got the bad end of that stick. But ostensibly this came about, GDPR did, because Visa had a giant hack in, I believe it was 2014. And when the EU authorities said, hey, what are you going to do about this? How are you going to protect people? They said, not our problem. It's not in our hands anymore. And the EU actually stood up to them and said, no, that's not how this works. So the good news is more and more states and countries are taking note of this and saying, yeah, this is what we want to do because our data privacy is a commodity and it can't be moved around willy-nilly anymore. So GDPR applies only in certain cases, but it applies to people in the EEA, which is the European Economic Area. So it's more than just the EU, it's the whole of everybody in East, West Europe, that kind of thing. It is a process that regulates personal data, regardless of whether the processing took place in the EU or not. So even if it's EU data that's being processed here in the States, GDPR applies. Excuse me. If the company that is processing is not established in the EU, they have to be either offering goods or services to people in the EEA or alternatively monitoring their behavior. This is where those clear pixels and web beacons come in because that counts as monitoring. When I talk about processing data is really small. That could mean putting your name in a web page. That means putting your phone number in an Excel sheet somewhere, or even ostensibly just having your details in an email. So if you were to email customer service somewhere, they are processing your information by having that information in their email. So just know that you have a lot of rights and they will still apply to you even though you may not be an EU resident. You have the ability to assert some of these same rights. If a company violates GDPR, and this is the fun stuff, it imposes both criminal and civil penalties in any of the EU states. It's just each of the states has to actually impose the penalties themselves. And the amount is either up to 10 million euro or 2% of their total worldwide annual revenue. And we're talking like a company like Facebook or Google, that's a lot of money because we're not talking about net, we're talking about gross here. So that's going to ostensibly be a really big incentive for them to want to protect your data. And you should take that to its fullest extent, honestly. So how does GDPR actually apply? It means that it restricts personal data processing. So if a company wants to store your data in their email, in their spreadsheets, in anywhere in their system, by collecting it, recording it, organizing it, deleting it, anything of that nature, they then need to start applying GDPR rules if the person is located in the EEA. What type of data is included here? Well, we mentioned before PII includes phone number, name, email address. For GDPR, it also includes job title, any online identifiers. So if you've got a screen name or a user number, that also counts. Your employment history counts, which I thought was very interesting. Any education and training, so like LinkedIn, anything on your LinkedIn profile or any kind of Indeed profile, that would count. And any financial payment details like credit cards or your PayPal or something. Any personal data that would require a higher standard of care would include racial or ethnic origin, your political opinions. So if you decide you are going to go in favor of one political ideology or another, that is a highly protected category. Any religious beliefs, health and sexual orientation, and any genetic or biometric data. And we talked about biometrics before with the face and the irises. So, how do you know if the company you're dealing with is bound by GDPR and you might be able to talk to them about this? Well, do they offer any of their goods and services in an EU language or currency? EU languages include things like French, Spanish, Italian, Portuguese, that kind of thing. Also, is there an EU data subject that can place orders? So do you allow people from the UK to place orders? Do you allow people, because even though UK is no longer EU, they are part of the EEA, so it counts. Do you have the ability to place orders from Italy? That kind of thing. Do they, on their webpage, refer to any of the EU countries? If yes, there you are. Do you offer delivery of your products in the EU member states? Same thing. And also, are there any kind of domains that are specific to EU? So if you've got any of those, GDPR is probably going to apply and you're going to end up with, yeah, we probably can do something for you. If you take absolutely nothing else from this talk away today, it's you have rights, and it's usually pretty good that you can get them asserted, regardless of whether it specifically should apply to you or not. So now that GDPR is in this world, you have the ability to say, no, I want some of that. I want to know who is processing my data and how. I want to know if I can delete my data. It doesn't matter that you're not necessarily located in the EU or California or what have you. You have gained those rights by virtue of these things being applied, and usually they don't want to have to separate all of the individual locales. So they'll have one system in place, and it never hurts to ask to be deleted. So we had a lawsuit come through called Schrems, and this was really big. It passed recently, well, kind of recently. It was actually in 2020, but it's come into its own in the last year. Schrems was an attorney. The Schrems 1 case happened because they found that their data that was located in Ireland was being processed on US servers by Facebook. And they said, this is not acceptable. I don't want my data, my Facebook data, being processed in the US, because we all know that the 3-letter agencies and the police have access to our Facebook data. They've given backends in Facebook. And the court said, all right, well, we're going to rule in favor of you, but only because you can say this. And the appellate court said, no, screw it. We're not doing this. There's enough protections based on the prior Privacy Shield, it was prior to Privacy Shield, that protects you and gives enough outs for you to seek redress against Facebook. And so Schrems tried it again about 5 years later and said, look, they're still doing this. They agree that they wouldn't do this anymore, but my data from Ireland is still being processed in the US. This is not fair. At this point, we had a different president. We had a different person in the FTC, the Federal Trade Commission, and the Federal Trade Commission ostensibly told the EU, yeah, we don't give a care. We're not going to prosecute anyone. Who are you kidding? So ostensibly, the prosecutor in the UK court said, all right, if the US doesn't care, fine. We're going to say that they are invalidated. There are not enough protections for US people. So Schrems 2, the result of which said, okay, we're now going to rule that Privacy Shield, which was the thing that allowed for prosecution mechanism in the EU or in the US of bad actors, is no longer valid. So any protections that we said were in place are done, and you've got to have extra protections. The standard contractual clauses are what came out of that. So when a business makes a contract with another business, there needs to be an underlying set of regulations that say, here, this is what's going to govern the behavior in case there's a breach. And ostensibly Privacy Shield said, hey, we have this separate document that allows us protection and we don't have to worry about an extra document. Because of Schrems 2, the standard contractual clauses came to be, and it's a, I believe, 27-page document that has call-outs for depending on how you are processing the data. Are you a processor? Are you a controller? The definitions of which are, if you are a controller of data, it means you take data in from a consumer and you either hold it or send it out to be processed. A processor is somebody who receives data from a controller and they do something with it. They store it, they organize it, they modify it, something. So within the new standard contractual clauses, it broke it down to the smallest level so that everybody could have granular responsibility when it came to data. So there's controller to processor, controller to controller, processor to processor, and processor to controller. Those are the 4 different modules of the standard contractual clauses. Now, why does this matter to you? This means that when you give your data to Facebook, depending on who gave your data, was it another company, was it you, that's what's going to govern what responsibility they have to you. Now, because of what's been coming to pass with Meta, God, I hate saying that, because of what's been happening with Meta and the UK prosecuting them, the France prosecuting them, the German courts prosecuting them, they are building up a really bad reputation. So as it turns out, There's probably going to be stuff coming down the pike in 2022 and in 2023 against Facebook that requires them to change. So keep your eye on this space. But as of right now, they have, unfortunately, the way to sort of shove you off as a consumer. I don't think that's going to last forever. So definitely keep your finger on the pulse of that one. Last year is when the new contractual clauses had to start being used, and by December of this year is when they're going to start the prosecutions. So keep your eye on this space. Also, right before next MAGFest, to see who's going to be on fire. It'll be fun. We can toast marshmallows. All right, so who does Schrems 2 apply to? What businesses that you deal with every day is this going to be applicable to? Any EU-based companies that are sharing data with providers in other countries. So for instance, Amazon has separate EU and US things, but there are other companies like, I'm not sure, Fantasy Flight games, they share across. They don't have separate EU servers and US servers. So when you have data sharing across lines, that's when Schrems 2 is going to be involved, and they're going to have a higher standard of protection. Also, non-EU based entities like Fantasy Flight are subject to that would otherwise be subject to GDPR and are sharing information across state lines. Also, non-EU based entities that are processing or receiving personal data. This means all the data brokers, all those ones who are buying the data from the EU and are otherwise shooting it off elsewhere. A really good example of this is Microsoft. Xbox actually takes a whole bunch of your data and they sell it off to other places. So being able to identify, hey, I have extra protections because GDPR and Schrems 2 has come down when it comes to my Xbox data, and making sure that you know your rights is super key in this world. All right, what is our equivalent here? Ccpa. This is the California rule. This is ostensibly what the US, or at least California, came up with as an answer to GDPR. The unfortunate part let's start again. The good part about Ccpa, it was intended to be implemented just like GDPR. It was intended to protect consumers. It was intended to give you the ability to fight back against the big companies. The bad news was it was crafted by a bunch of politicians. So in a lot of ways, it's like being slapped with a wet noodle. It's very confusing and very alarming if you're asleep. So the Ccpa is good, but it could be a lot better. So it came into being in 2020 at the very beginning. We have modified it into Cpra. I'll talk about that a little bit later, but right now it applies to for-profit entities doing business in California that are one of the following thresholds. Either gross revenues larger than 25 million, so most large game companies, that kind of thing, and or also additionally buys, receives, sells, or shares personal information for consumers and households. The 50,000 consumers I crossed out there, the number has been increased by Cpra to 100,000, but 100,000 people is not that much for a big company. When we talk about EA Games, when we talk about all the stuff with Sony and the PlayStation, when we talk about any of these big companies, 100,000 is a drop in the bucket for them. There used to be another piece that derives 50% or more of its annual revenue from selling consumers' personal data, but in a stroke of genius, that no longer applies. So you do not have to sell the data to be under Ccpa's legislation. So it also applies to entities that are both these things. The reason why I crossed these out is commonly controlled businesses are not covered if they are unless they're specifically sharing consumer data. So these used to be the case, but Cpra changed them. Now, the fun part. What is PII actually included in here? Because they changed it from the GDPR definition. GDPR had a pretty solid definition of what PII is. First and last name, we already covered. Physical address, email address, right, makes sense. Social security number, absolutely. Information that a website collects on you makes sense. And any other identifier. I love this section of CCPA. It is my favorite because your personal information includes your IP address, your gait, that is how you walk and what you look like when you walk, your smell. Please, if you find a company that is willing to code you based on your smell, I want to know about this. Find me. I think that would be hilarious. Also, physical description. So if somebody managed to describe any moles you have, that would also be personally identifiable information. Similar to the smell, if you find this happening, please let me know. I would be so excited to hear about it. All right, so companies that are subject to CCPA, what rules do they have to follow? They have to update and create privacy notices. If you find a website without a privacy notice, you can force their hand. Please do so. If they have to provide consumer choices regarding redisclosing and selling personal data, that means if they've taken data in and they want to sell it off to another company or share it with another company, they have to provide notices and choice. So definitely hold them to that. It also imposes restrictions on data monetization and business models. That means that there are certain things they can and cannot do with your data for money. I'm not going to get into the details of that, but that's definitely something to look into. And in their privacy notice, they should be describing exactly what they are doing with your data. If they aren't, they are in violation of CCPA. CCPA was created just like GDPR to support a consumer's right to access any of their personal information, request deletion of that personal information, and receive any of the requested data in, a portable format. That means they can't give it to you in object code. They actually have to make it readable, so it'll work. If they don't comply with this, the penalties are a little less than GDPR, a little less teeth, but it's $2,500 per violation. If we're talking about a single point of data being shared the wrong way once, that could be millions. In addition, $7,500 per intentional violation. So if they knew they were selling data and they just didn't do any registration or anything, that's a lot more. And private rights of action for the actual consumer. This is where that lawyer Angela comes in, just for the simple fact that she'll point you in the right direction of any class actions dealing with this kind of thing. So what did Cpra change? We talked a little bit about this, but there's new data categories of sensitive personal information. That's like your social security number, driver's license, passport, financial information. That's where the biometric information comes into, but also any non-public communication. This is going to be huge. I guarantee you, as we've been doing all of these meetings online and people have been spending more time on Discord and Slack and everything else, we're going to find all of this non-public communication either coming to the fore or having companies actually prosecuted under CCPA because of this, because there is more sharing of more non-public information than ever before. It also changes the covered entities. We talked about the 100K versus 50K for sharing data. It also has application to those processing high-risk data. It makes them have regular cybersecurity audits. I don't know if any of you guys have run into NIST. Those are the national standards. Those have to be implemented, and California has actually been doing a really good job of requesting audits of larger companies. The right to opt out, additionally, includes sharing personal information to third party for cross-context behaviorals. What this means is, if you're not necessarily selling directly, if the company is not selling your information directly to another one, instead they're selling it to a third party who's aggregating and saying, okay, here are the categories in which these people belong to, and they're selling down, that counts as a sale. So you have rights. It's just a little hard to parse sometimes who has your data at the time, but you get to request them. And like I said under GDPR, I don't care if you are not living in California. Companies have had to make these changes. And if we're talking big companies like Amazon, like Sony, like Microsoft, you have rights that you necessarily have not necessarily, I'm just repeating myself, you have rights that you have not necessarily been utilizing. And that's just because you didn't know. So you do not have to stay within your locality. You can request things. Look, the worst thing they're going to tell you is no, right? And what did that cost you? 15 seconds? So it's worth it to be able to assert your data privacy rights, because it's not just enough to be your own person, have your own money. Those data privacy rights are worth money, and they are yours. So assert your right over them. In addition, consumers now have the right to access their data, but also to modify and delete it. And that means that there must be third-party pass-ons. So that means if you find that another company still has your data, you have the right to say something. So for instance, myself, I had signed up on change.org for one of the petitions or whatever, and I used a very specific name that was not mine. I found that they sold it to the Democratic National Convention, who then decided they were going to use it through all these different parties. Now, I'm from Chicago. I used to live here in DC, but I no longer do. Turns out every single mayoral race, gubernatorial race, everything that comes through now solicits me because the Democratic National Convention sold my information to every single one of them. Under Ccpa or Cpra, I would have the ability to say no. And I have been. I've been stepping back to all of these people that have been reaching out to me and saying, you absolutely have no right to do this. I am not in your jurisdiction. You don't get to play this way. The DNC has not, unfortunately, responded to my emails yet, but I assume that once I get angry enough, I'll get a response from them. So we're still working on that one. In addition, there's increased liability for misusing data for those under 16 years old. Like I mentioned earlier, COPPA is a really big deal in this country. We want to protect those who are considered minors. So there needs to be upgraded and updated standards for where there's children involved. And Ccpa and Cpra correctly identified that this was a necessity in our society. So we are putting more protections in place for children. So, what else is there out there? We covered Gdpr, we covered Ccpa. I said that I'd talk about a couple more countries and what have you. 80 countries now have data privacy rules of one stripe or another. Even China has data privacy rules. Of course, unfortunately, the Chinese government's data privacy rules usually end with, and you have to give us a copy. So that's not quite the same. But I mean, the new registration laws that we're talking about in the Philippines, the harsh ones in Brazil, the ones that have come through in Russia even, there are data privacy laws and there are some consumer protections there. So it really makes a lot of sense to be able to assert your rights wherever your data may be transferred. Australia has some really good stuff on the docket. They're going to be modifying those this year. Same with Mexico. Mexico's got some really good laws. So numerous states also have privacy laws, but they may not be as strong as Ccpa. Virginia passed theirs this last year. It's pretty much a page out of the Ccpa playbook, so the California one. But other things count as data privacy. For instance, there's the Illinois Biometric Act, which allows for or does not allow for the sharing of biometric data. My favorite is probably the case dealing with this that I call the poop case. So this law actually came about in Illinois because there was a giant airfield that had these hangars on it, and two of these guys that were security guards. This is an actual case that happened. And during the course of the night, someone took fecal matter and smeared it all over the side of one of the airplane hangars. So the boss comes in the morning and goes, all right, which one of you did it? And both of the security guards go, it wasn't us. Are you kidding? So he says, all right, fine, you have to poop in a jar for me so I can test this. And the employees went, I don't think so. That's not happening. So it went all the way up to the Illinois Supreme Court, and it turns out that no, you cannot make your employees poop in a jar so that you can test their DNA. And thus the biometric laws were established in Illinois. So ostensibly what it says is you're not allowed to force your employees to give up DNA for the purposes of their positions. It is their personal private information. But I always like the poop case. In addition, New York, Massachusetts, they've also implemented laws, but we have, and Colorado I don't have on here. Colorado is the other one that passed last year besides Virginia that has comprehensive data privacy laws. So these are all going to be in the mix and informing all the other states as they put down roots in data privacy landscapes. So make sure that you are keeping your finger on the pulse of this, because your rights are coming up fast and soon. If there's ever any questions about what are my rights in this state, I wouldn't recommend blog searches. There's a lot of shady people in my profession who want to just suck you in when there's no whatever. There are data privacy professionals. The IAPP is a really great organization for sharing information regarding data privacy laws. That's the International Association of Privacy Professionals. So you can absolutely find people to help if you need it for your business or you just want it for your own protections. They have really good articles and what have you there. All right, that was a whole lot of talking. Does anybody have any questions? Yeah, please.
Let's say a company such as W has like a security breach where all they want to do is basically.
Yeah.
What rights do let's say the consumers have in that regard?
So the question was, if a large company has a data breach, what rights do consumers really have in that aspect? Well, the good news is, because there are so many privacy protection laws, there are rights that you do have. You don't have to be abused by companies. The hard part, however, is going to be banding enough people together, because in a lawsuit, you need some sort of injury or a harm that happens and some valid way of solving that harm, making you whole again. Usually when we're talking about a data privacy breach, because, really, the internet is still in its infancy. We're talking about many people started adopting it in maybe 1995, 97. We're not that far off. So what we understand about data privacy and what we understand about what we should have rights in hasn't evolved yet. So that's why you still need a class action, many different people to come by and say, all right, as a group, we've been harmed. But usually if there's a data breach, there is some law firm or law firms on it, and you can join those and speak out and say, no, I was one of the people that was harmed in this, I want money. So for instance, Wizard World, if you've ever been to any of their cons, they do a bunch of anime, sci-fi, all sorts of things. They got breached, and they actually had credit card information stolen from a lot of people. A friend of mine had her information stolen, and there was $2,000 charged on her credit card. So I gave her to another friend of mine who does class actions, and they sued Wizard World. And the people who were named plaintiffs got higher sums. So they were getting more like $5,000 and $7,000 to actually recoup their expenses of doing this. If you're not a named plaintiff, there's still opportunities for settlement to try and get you whole again. Outside of that, you can always demand credit monitoring. That's always a really good one to do. And if you don't already have credit monitoring, that's a fantastic service. The other alternative to that is freezing your credit, but that makes it hard if you want to do things like open a credit card or get a car or anything. So credit monitoring is wonderful, because having that in your back pocket and being able to monitor how your data is being shared without your knowledge is a really, really great piece of information. Does that kind of answer your question? Awesome. Anyway, yes. While they have the right to, the question was, if a company operating in the EU, do they have the right to deny you your request to either access or delete your information? If you're not an EU resident. The answer, unfortunately, is yes, they have the right. However, the good news is most companies do either not have the funding or the wherewithal to separate their populations. So that means that all the data is mixed in, and if you make a request, there are very few companies out there that aren't ginormous like Google that are going to separate you in your lists and say, oh, no, this one's a non-EU resident, so they don't get this information, and this one is an EU resident. Because the fact is, You don't have to have a Gmail EU address. If you just have a Gmail address, you don't know where somebody is. So outside of making you produce your driver's license, they don't know where you're from, and they have to take your request at face value. So that's why I said assert your rights like frequently and often, because the worst they can tell you is no. It's more likely than not that they are going to comply because it's literally easier for them to do so. And what else? So, how to follow the rules if you're a business. Get a lawyer. No, really. If you have a small business, seriously, get a lawyer. I'm not just hyping my profession here. The unfortunate part about the law is it's been written as a whole bunch of spaghetti, and it's really hard to read spaghetti, let me tell you. So they've made it inaccessible to the general population, and it just really helps to have somebody that's paid far too much for a small piece of paper with their name on it. In addition, make a data map. I actually recommend this one to consumers too. Who has your data? Who do you use on a regular basis? Do you use Gmail? Do you use Facebook? Do you use Twitter? How is that actually broken down in terms of privacy? Do you know what your privacy settings actually look like on Facebook? When's the last time that you've looked through their settings? They've changed them actually since, I want to say the last 3 months they changed them. So if you haven't done a privacy checkup on Facebook about what they're sharing about you, please do so after this panel, because honestly, it will only serve you well. In addition, do a security audit. When's the last time you changed your password? How many times do you use that password across how many different services? I cannot recommend enough getting a password manager like LastPass or something like that. It will seriously make your life easier, and you can have longer, more secure passwords that you don't have to remember on a daily basis. So anything you can do to make security higher with the least amount of effort on your part, like password managers, do it. That's the best thing you can do. In addition, create external and internal facing policies and follow them. If you're a business, if you're running a small business, you want your employees not to share their details and not to share other people's details. Don't write stuff on Post-it notes. That counts the same for you. You know, if you have a household where you share a bank account with somebody or you share computer information with somebody, how are they sharing it? How have you talked to them about this? Make sure that you know how you are having your data shared, even by those who are closest to you. Personal example, I found that I have 2 phone numbers. I found my mother was giving my direct phone number to my phone, just willy-nilly on forums. I'm like, thanks, Mom. That's awesome. I appreciate that. Please don't do that again. In addition, be clear on how you want your data used with companies. If a company has a form, those cookie notices. You do not have to click OK. Every time you get a cookie pop-up notice, if you don't actually click OK, they usually don't get to store stuff. In addition, if you click more information, those more information links actually usually pop up a thing where you can go through and say, oh, I want this, I don't want this, I want this. There's granular options. Utilize those always. You don't need to be marketed to by everybody and their brother. If you just bought a trinket on Amazon, you don't need to see that ad on Facebook anymore. All you need to do is uncheck those notices. And don't go it alone. Like I said, there's the IAPP, there's lawyers, there's other blogs out there. There is information to help you. There is no reason to think that you're lost in this data sea. There are people and places that you can find information easily. So, now that I've talked at you about relevant things, myself, irrelevant. This is an old slide. I haven't changed this. I found out I was presenting like 2 hours ago. So, I am former general counsel of a tech company. I am no longer outside general counsel. I'm actually now the global cybersecurity counsel for Yahoo. Again, I do not represent Yahoo in any of their viewpoints, but I have recently gone back in-house in the last 2 months. So I do a lot with cybersecurity, obviously, and data privacy. Foundry General Counsel, my former firm, was outside general counsel. But I do recommend, if I can, to always consult a cybersecurity or privacy attorney for all of your business needs that you may have. So, any final questions? Why is the sky blue? No. All right, well, I appreciate you guys, joining me for today. If you have any additional questions you want to ask, feel free to come up. But yeah, take care of yourself, because seriously, your data privacy is part of you, and you don't want anybody marketing to you that you don't want marketing to you. Cool. Thanks, guys.